Are you contemplating selling a probate property right here in California? What if I told you the entire journey might unfold quite a bit slower than you're imagining? And perhaps, even more importantly, that one critical misstep early on could easily add months and months to your timeline. Hi there, and welcome to the channel. My name is Gary DiGrazia, your go-to for everything probate real estate related. And today, I want to talk to you directly about a topic that often brings with it significant responsibility, and let's be honest, a lot of uncertainty. Navigating the probate home sale timeline here in California. If you find yourself in the role of an executor or administrator for an estate in California that includes real estate, you already know there's a complex web of legal steps ahead. And one of the biggest questions I hear time and time again is always, Gary, how long is this actually going to take for me? But let's agree, the clock actually starts ticking the moment a loved one passes. And managing an estate, especially one with real estate involved, can feel like a relentless race against time and mounting expenses, doesn't it? Today, I'm going to guide you through the California probate home sale timeline, from the initial filing all the way to closing the sale. We'll meticulously break down each phase, give you honest, realistic expectations for how long each step typically takes, and most importantly, equipped you with the precise knowledge to potentially sidestep any costly delays. My ultimate goal here is to reduce your anxiety and help you plan effectively every step of the way. But before we jump into all of the details, let's touch on that critical misstep I hinted at earlier. There's one common, seemingly innocent action many administrators or executors take early in the probate process that, without even realizing it, can easily delay your sale by several months. Now, I promise to reveal exactly what that is and how you can avoid it a little bit later on in this video. So make sure you stick around and you watch all the way to the end so you don't miss that point. All right. Let's pull back the curtain on the California probate sale timeline, shall we? Remember, these are all general estimates. Every single probate case is unique, but this framework will give you a real solid understanding of what you should expect. Phase 1, petitioning for probate and getting appointed. This is truly where your journey begins. After a loved one passes away, a petition is filed with the county superior court to officially open the probate case and eventually appoint you as the executor or the administrator of the estate. Typically, this initial phase can take anywhere from 2 to 4 months, sometimes stretching out longer, depending on specific court caseloads and if there are any heirs objecting. Now, you'll need to gather important documents, you'll need to notify heirs, and attend a hearing. So getting professional legal help here is genuinely crucial to ensure that everything is filed correctly and efficiently for you. Phase 2, inventory and appraisal. Once you're officially appointed, your primary duty becomes inventorying all the estate's assets, including the real property, and having all of the valuables appraised. The court will appoint a probate referee to appraise the real estate. This process alone can easily take another 2 to 3 months. The appraisal is critical because it does establish a base value of the property at the time of death, which is so important for eventually coming to selling the property, but more importantly, for tax implications for you and the estate. Now, it's critical for you to understand something about the probate referee appraisal. It is not the same as an official licensed real estate appraiser appraising the home, something that you would get when a buyer makes an offer on a property. The probate referee typically does not enter the home, nor do they take into consideration its current condition, if there's any needed repairs, or any other material facts that significantly impact the home's market value. So while it's important for the court purposes and for taxes, don't rely on the probate referee's valuation as a true listing price for the home. The true market value of any home is ultimately determined by what a qualified buyer is willing to pay for the home. Phase 3, marketing and finding a buyer. This is where the property actually gets listed and all the marketing begins. You'll want to work with a specialized probate real estate agent for this part. The time it takes to find a buyer, it can vary based on current market conditions in the area of the probate home, the probate home's condition, and how it was priced. But typically, once the property is officially on the market, you're looking at anywhere from 1 to 3 months to secure an acceptable offer from a qualified buyer. Critical point for you here. Working with an agent who is truly experienced in probate sales, that should be non-negotiable. Probate agents like me understand the unique disclosure requirements, specific pricing strategies, probate guidelines, and most importantly, how to expertly navigate transactions that might need court approval, or just as critically, how to leverage full authority to bypass those delays. Phase 4 brings us to a critical distinction that profoundly impacts your timeline: the type of authority granted to you as administrator or executor specifically. Full authority versus limited authority under what's called the Independent Administration of Estates Act, or the IAEA. Having been granted full authority by the court is the single biggest factor in streamlining your probate home sale. Why? Because with full authority, you can generally sell the property outright with far less court intervention. It's much like a traditional real estate sale. There's just some added probate documentations and extra steps that we have to provide in order for the sale to close. With full authority, this means no petitioning the court for approval each time you accept an offer, and no public hearings where the property is subject to an overbid process. The overbid process, while intended to ensure beneficiaries receive the highest possible price, often ends up just narrowing the buyer pool significantly, as not all buyers are willing to participate in a lengthy, uncertain court procedure. Thus, significant time savings and a broader market appeal for you comes with full authority. Without full authority, most probate sales in California require this court confirmation and potential overbid period, which adds a minimum of 1 to 2 months to your timeline after an offer has been accepted. That's assuming everything goes perfectly. Full authority gives you, the administrator or executor, much greater control and flexibility. While you still have to act in the best interest of the estate and the beneficiaries, and typically provide them with notice of your intent to sell, you bypass much of the direct court oversight on the sale itself. This makes the process dramatically faster and more akin to a conventional real estate transaction. It truly is the path of least resistance for you and for expediting the sale of any real estate that's going through probate, and something your probate attorney will likely aim for if the estate qualifies for full authority. Phase 5, closing the sale. After you've found a buyer and crucially either navigated court confirmation if you had limited authority or leveraged your full authority to proceed, you then move to the standard escrow and closing process. This is quite similar to any other real estate transaction involving appraisals, inspections, and loan underwriting if the buyer is getting a mortgage. This typically takes 30 to 45 days to complete for you. So if we tally all that up, the shortest typical timeline for selling a probate home in California, assuming you have full authority under the IAEA and everything goes smoothly with no delays, is around 6 to 10 months from the date of petitioning for probate to close of escrow. If you have limited authority and require court confirmation, then you're looking at 8 to 12 months and possibly even longer. It's not all that uncommon for the entire process to stretch 12 to 18 months or even longer. It's important for you to be prepared for this extra time if it ends up coming up. So what factors can influence your specific timeline? Court caseloads are a huge factor. Some California counties simply have much busier probate courts than others, which will directly impact your wait times. Estate complexity, obviously, if there are disputes between heirs or significant debts that will prolong your process. The property's condition. If it needs a lot of repairs, that can definitely extend things. Whether you, as the executor or administrator, have full authority versus limited authority. Having full authority under the IAEA makes a tremendous difference, potentially saving you months in the selling phase. As we discussed, with full authority, you can often sell the property without court confirmation, effectively skipping that entire 1 to 2 month step, provided you give proper notice to the interested parties. Now, this is game changer for you. The speed that this allows when you're selling a home in probate allows you to move much closer with a conventional real estate transaction timeline. Again, there's just a few extra added probate documents that must be in escrow in order for the escrow to close the sale. And as long as you're working with an experienced probate real estate expert like myself, you have nothing to worry about. All right, remember at the beginning when I mentioned that one crucial misstep that many administrators and executors make, inadvertently adding months to their probate timeline? It's time to reveal exactly what that is. And it's simpler, yet far more impactful for you than you might think. The critical misstep is spending estate funds on significant repairs or renovations to the property without first obtaining explicit court permission or having been granted full authority under the IAEA to do so. This is a trap you absolutely want to avoid. Here's why this is such a problem for you. As an executor or administrator, you are a fiduciary. Your actions must always be in the best interest of the estate and its beneficiaries. So spending a significant amount of money on a property, even if you believe it will increase its value, can be seen as an unauthorized expenditure. If you don't have the explicit power by the court to make these decisions, it could be a problem. If you have limited authority or no court order specifically allowing repairs, and you decide to put on a new roof or remodel a kitchen or even undertake extensive landscaping, you run a huge risk. The court or even disgruntled heirs could challenge these expenditures later on, and this could lead to delaying the sale requiring you to personally repay the estate or even losing your appointment as administrator or executor. It's a serious risk to you and to your personal liability. Even if you have full authority, it's still wise for you to consult with your probate attorney. The general rule is for properties to be sold quickly in probate, and they're typically sold as is. Minor cleanup, basic staging, we use virtual staging. That's all usually fine. But major structural changes or capital improvements, that needs careful consideration and usually a specific court order or the explicit approval granted by full authority for you to proceed with those activities. The key takeaway here is always consult with your probate attorney before spending substantial estate funds on property repairs or any improvements. This simple step can save you months of headaches, potential legal battles, and significant financial repercussions. Navigating a probate home sale here in California is undoubtedly complex, but with the right knowledge and a clear understanding of the timeline, it truly doesn't have to be overwhelming for you. Remember, from petition to close, you're generally looking at 6 to 18 months with court caseloads and, more importantly, the type of authority you have, full versus limited, both playing a huge role in your specific journey. If you're facing a probate sale in California or just planning for one, please don't try to go at it alone. The right team, a skilled probate attorney, and a specialized probate real estate agent will make all the difference, helping you avoid any pitfalls and navigate through the process as smoothly and efficiently as possible. Before you go, make sure you download my free probate real estate guide for administrators and executors. Just click the link in the description below and you'll find it there. Also, if you'd like to have a one-on-one detailed conversation about your unique situation, go ahead and schedule a free no obligation consultation with me. The link to my calendar is also in the video description, or you can scan the QR code that is on this channel's homepage. If you found this video helpful, please give it a thumbs up. Make sure you subscribe to this channel for more valuable probate real estate insights and tips, and be sure to hit that notification bell so you don't miss any of my upcoming videos. And please tell me, what is your biggest question about selling a home going through probate? Let me know in the comments below. I read every comment and I respond personally. But for now, thank you for watching, and I'll see you in the next video.